Hi, I'm Chris Chimicles, president of Angeion Group, and welcome to our Leading Litigator series. Our series brings together some of the best and brightest class action practitioners from both the plaintiffs and defense bars, and most importantly, the attorneys that made case law. Enjoy our series.
Hi, I'm Steve Weisbrot. Welcome to another edition of Angeion's Leading Litigator video series. Today it's our privilege to have Rich Goetz from the law firm of O'Melveny & Myers joining us. Rich co-chairs the products liability section as well as the consumer class action section here at O'Melveny, and he's a member of the executive committee. Rich, thank you so much for joining us.
Thanks, Steve. Appreciate the opportunity.
So Rich, we've recently seen the Can't Believe All decision come down. I'm curious your take on the decision from the defense perspective.
I think it all boils down to the last two sentences of the opinion. That's where the debate is, where the court in the majority opinion said if you actually pay money into court or to the plaintiff, him or herself, and get a judgment, that would in fact moot the class. The problem comes in looking at the breakdown of the votes. It is a 6-3 opinion with Justice Thomas in the majority but concurring in the judgment. It's plain that Justice Thomas would agree with those last two sentences, making it a 5-4 opinion. Justice Kennedy, in an earlier opinion, the Genesis case arguably went the other way and could be a flip vote, making it 5-4 in favor of those last two sentences, but we've lost Justice Scalia, of course, which would lead you to a 4-4 tie. So it's very difficult to do the math, figure out where we're going to be, but I think we can all agree that those last two sentences are the most important part of the opinion.
So obviously you just mentioned the loss of Justice Scalia. Clearly someone who is integral to the class action jurisprudence of the last however long. Where do we go from here?
Well, he's been very important in the last several years. He wrote the 5-4 opinion in Walmart. He wrote the 5-4 opinion in Concepcion. He wrote the 5-4 opinion in Comcast. He wrote the 5-3 opinion in the American Express versus Italian Colors case. It would have been 5-4 but for Justice Sotomayor having to recuse herself. So those are four really big class action cases in the last several years that have cut in the favor of the defense. And the obvious question is, what does Justice Scalia's departure mean? You see some companies in the news settling class actions, a very large one recently for several $100 million, and the speculation was that was due to Justice Scalia leaving the bench. I don't know. I think it's a little bit more complicated than that. When you look at the Walmart opinion, for example, it was unanimous on the B2 issue in the favor of the defense. None of the justices in Walmart said that was a class that should be certified. You look at what Justice Scalia did over the years, and you have the Shady Grove opinion, for example, where he said a class action should go forward in federal court, even though it couldn't go forward in state court because of a New York statute that would have prohibited it. And then you reach all the way back to what's the origin of the modern day of class actions, and that's that Amchem opinion. And who wrote that? It was Justice Ginsburg. So I think the real question is, we've seen a lot of activity in the last few years on class actions. It's occupied a fair amount of the court's time. Will it continue to do so? That's an open question.
So one of the things that's pretty unique about your practice is that you handle both consumer class action lawsuits and also mass tort or product liability cases, however they might be named. I was curious about, from your perspective, is there a difference going into these cases in terms of trial strategy or trial tactics, and what those differences are, if any?
Well, our whole team does that, so it really permeates the way we look at cases. An example is we've all been involved in cases where there are multiple plaintiffs who potentially could try their case together. And we've looked at and seen the difficulties that creates, both for the plaintiff and for the defense. And we try to translate that into how we look at a class action, which is essentially doing the same thing but with just a lot more plaintiffs. From the defense side, the risk you face is the creation of a composite or perfect plaintiff, where each plaintiff fills in the gaps in the other's proof. From a plaintiff's perspective, a plaintiff with a strong claim doesn't want to have those claims weakened by a plaintiff with a weaker claim. That's true in a class action too, particularly when you try cases by formula, and it becomes a defense problem because if the formula isn't fair or guaranteeing due process, you face a prospect down the road that any class action result might be challenged. Another example is what we call proximate cause in law school, and now the ALI tries to call it, and it's probably an easier phrase, scope of liability. There are situations where people have been arguably harmed, where for reasons of public policy in the tort context, we say they're simply not going to be compensated. For example, you see a very bad car accident, maybe somebody driving even your type of car. Unless you're related to the person in the car, you're not going to get compensated. You're not going to get money. As a matter of public policy, the scope of liability is framed so that only a much narrower group of people can get money. You switch over to the consumer protection statutes on the class action side, and often those limits are ignored. Somebody who reads a label on a product that has a mistake in it but doesn't necessarily do anything as a result says they have a claim. Somebody who learns that they could have been harmed by a product but never were, so say they have a claim. We've argued with some success that these principles of scope of liability or proximate cause ought to play into the class action context, the consumer protection statute context as well. And then something as simple as whenever you have a tort case, the first thing you do, or one of the first things you do, is look at the jury instructions you're going to have. That dictates how you're going to prepare your case. We do the same thing in a class action, and it helps both prepare your case and to identify those issues where maybe it's just inappropriate to have a class action.
Makes a lot of sense. Rich, that was fantastic. I can't thank you enough for being here. We really enjoyed having you on this episode of Angeion's Leading Litigators series. Thank you again.
Thanks, Steve. I really enjoyed chatting. I appreciate the time.